So what exactly does the law have to say about public holidays under Ontario's Employment Standards Act? Before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. You might think that public holiday laws are pretty straightforward. When a public holiday comes along on the calendar, you get the day off work, and that's it. Well, unfortunately, it's not quite that simple. My name is Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. Public holidays are regulated by Part 10 of the ESA, and that part includes sections 24 to 32 of the ESA. Since the wording of these sections can get unnecessarily complicated, this video will explain each of these sections in simple terms, so anyone who is an employer or employee can easily understand their rights, assuming the job is in Ontario and the job is regulated by the ESA. Starting with Section 24, it details how public holiday pay is calculated for employees. Essentially, an employee's pay for a public holiday is calculated based on the total amount of regular wages and vacation pay they earned in the 4 work weeks preceding the week in which the public holiday occurred. This amount is then divided by 20. Alternatively, if a different calculation method is prescribed by law, that method should be used to determine the public holiday pay. Additionally, Section 24, subsection 2 of the ESA addresses premium pay. This clause mandates that employers who are required to pay premium pay on public holidays must pay employees at least 1 1/2 times their regular rate. This ensures that workers are fairly compensated for working on days that are generally recognized as holidays, reflecting the extra value and potential inconvenience of working on these days. Moving on to Section 25 of the ESA, this section addresses situations where an employee performs different kinds of work in the same work week, particularly in relation to public holidays. This part of the legislation is significant for those whose job responsibilities vary within a single work week. Section 25, subsection 1 sets the stage for determining how public holiday rules apply to employees who do different kinds of work. Specifically, it applies to employees who perform a certain type of work that is exempt from public holiday rules under the ESA regulations, but whose job also requires them to perform other types of work that are not exempt. Section 25, subsection 2 then clarifies how to determine the applicability of public holiday rules in these cases. Essentially, the ESA's public holiday provisions will apply to the employee for that public holiday unless more than half of the time they spent working in that week was in performing the exempt kind of work. In other words, if the majority of an employee's work week is spent on tasks that are exempt from public holiday provisions, then the entire week is treated as exempt. Conversely, if the majority of the work is non-exempt, then standard public holiday rules under the ESA apply. This section ensures that employees who have mixed duties are not unfairly exempted from public holiday benefits. It recognizes the complexity of modern job roles, where employees might engage in a variety of tasks, some of which may be classified differently under the ESA. Moving on to Section 26 of the ESA, this part of the legislation outlines how public holidays are to be handled when they fall on a day that would ordinarily be a working day for an employee. Under Section 26, subsection 1, if a public holiday falls on a day that an employee would typically work and the employee is not on vacation, the employer is required to give the employee the day off. Moreover, the employer must pay the employee public holiday pay for that day. This ensures that employees are fairly compensated for public holidays, recognizing these days as special, non-working days, except in certain industries or roles where exemptions apply. However, Section 26, subsection 2 introduces an important exception to this rule. An employee loses their entitlement to this benefit if they fail, without reasonable cause, to work all of their last regularly scheduled day of work before the public holiday or all of their first regularly scheduled day of work after the public holiday. This clause is designed to prevent employees from extending their holiday period without authorization. It essentially means that if an employee is absent without a valid reason, either immediately before or after a public holiday, they forfeit their right to public holiday pay for that particular holiday. This section of the ESA is crucial in ensuring that both employees and employers have clear guidelines regarding entitlements and obligations related to public holidays, promoting fairness and responsibility in the observance of these days. Moving on to Section 27. This section addresses situations where an employee and employer agree that the employee will work on a public holiday that would ordinarily be a working day for that employee. In such cases, Section 26, which normally governs public holidays, does not apply. Under Section 27, subsection 2, if there is an agreement to work on a public holiday, the employer has two options. They can either pay the employee regular wages for the hours worked on the public holiday and provide another working day as a substitute holiday for which the employee will receive public holiday pay. Or, if both parties agree, pay the employee public holiday pay for the day plus premium pay for each hour worked on that day. Additionally, Section 27, subsection 2.1 requires the employer to provide a written statement to the employee before the public holiday, specifying the public holiday to be worked, the substitute day for the holiday, and the date the statement was given. This ensures clarity and formal acknowledgement of the arrangement. However, there are restrictions under Section 27, subsection 3 on when the substituted day can be taken. The substitute day must be within 3 months of the public holiday or up to 12 months after, if both employee and employer agree. Section 27, subsection 4 of the ESA meticulously details the conditions affecting an employee's entitlement to holiday pay and premium pay when they agree to work on a public holiday, covering various scenarios to ensure fairness. If an employee, without a reasonable cause, fails to perform any of the work agreed upon for a public holiday, they lose their entitlement under subsection 2, which means no substitute day off or public holiday and premium pay combination. However, if the absence is due to a reasonable cause, the employee still retains the right to either a substitute day off or the agreed combination of pay unless they also fail to work their last scheduled day before or the first day after the public holiday without a valid reason. In scenarios where the employee only completes part of the agreed work on the public holiday without a reasonable cause, they are only entitled to premium pay for the hours worked, forfeiting other entitlements like the substitute day off. Contrastingly, if there's a reasonable cause for not completing all the work, the employee is entitled to their regular wages for hours worked and a substitute day off. This entitlement is adjusted if the employee also misses their last or first scheduled day surrounding the public holiday without a reasonable cause, in which case they only receive premium pay for the hours worked. The section ensures that employees who fulfill their work commitments on public holidays are appropriately compensated, while also providing clear guidelines for situations where employees may not meet their commitments, thereby balancing the rights of employees with the operational requirements of employers. This section of the ESA offers flexibility for employers and employees to make arrangements that suit their needs on public holidays, while also setting clear guidelines and conditions to ensure fairness in these agreements. Moving on to Section 28 of the ESA, this section addresses the requirements and entitlements related to working on a public holiday, specifically for employees in certain sectors such as hospitals, continuous operations, hotels, motels, tourist resorts, restaurants, or taverns. So if your job does not fall into one of those categories, then feel free to skip this section. But if your job does fall into one of those categories, then this section is for you. According to this section, employers in these sectors may require employees to work on a public holiday that would ordinarily be a working day for them, and that is not a day on which the employee is on vacation. If the employer chooses to do this, then the provisions of Sections 26 and 27 do not apply. Under Section 28, subsection 2, when an employee is required to work on a public holiday, the employer has two options for compensating the employee. Firstly, the employer can pay regular wages for the hours worked on the public holiday and provide a different working day as a substitute holiday, with the employee receiving public holiday pay for this substitute day. Alternatively, the employer can pay public holiday pay for the day, in addition to premium pay for each hour worked on that holiday. Section 28, subsection 2.1 mandates that if a day is substituted for a public holiday, the employer must provide a written statement to the employee before the public holiday. This statement should outline the public holiday on which the employee will work, the date of the substituted day, and the date the statement is provided. There are restrictions on when the substituted day can be taken, as outlined in Section 28, subsection 3. The substitute day must be within 3 months of the public holiday or up to 12 months later if both employee and employer agree. Section 28, subsection 4 provides detailed rules about an employee's entitlement when they are required to work on a public holiday in certain sectors such as hospitals or restaurants. This subsection is critical in ensuring that employees who work on public holidays are fairly compensated while also addressing various work performance scenarios. Firstly, if an employee does not perform any of the work they were required to do on the public holiday without reasonable cause, they forfeit their entitlement under subsection 2. This means they would not be eligible for either substitute holiday pay or the combination of public holiday pay and premium pay. Secondly, if an employee fails to perform the required work on the public holiday but has a reasonable cause, the employer must either give the employee a substitute day off or pay public holiday pay. However, if the employee also fails, without reasonable cause, to work their last scheduled day before the holiday or the first day after it, they lose this entitlement. Thirdly, in a scenario where an employee performs some but not all of the required work on the public holiday without a reasonable cause, they are entitled to premium pay for each hour worked on the holiday but lose any other entitlement under subsection 2, such as the substitute day off. Fourthly, if an employee partially completes the required work on the holiday with a reasonable cause for not completing all of it, the employer must provide wages at the regular rate for the hours worked and a substitute day off, or public holiday pay plus premium pay for each hour worked. However, this entitlement is negated if the employee fails to work their last scheduled day before or first scheduled day after the public holiday without a valid reason, in which case they only receive premium pay for hours worked. Lastly, if an employee completes all the work required on the public holiday but fails to work their last scheduled day before or first day after the holiday without reasonable cause, they receive premium pay for each hour worked on the public holiday but forfeit any other entitlement under subsection 2. These detailed provisions in subsection 28(4) ensure that employees in specific sectors are appropriately compensated for working on public holidays while also setting clear expectations and consequences for attendance and performance around these days. This section of the ESA provides flexibility for employers in certain sectors to require work on public holidays while also setting out clear guidelines for compensating employees who work on these days, ensuring they are fairly remunerated for their work. Moving on to section 29 of the ESA, this section deals with scenarios where a public holiday falls on a day that is not a regular working day for an employee or a day when the employee is on vacation. In such situations, the employer is required to substitute another working day for the employee to take off with public holiday pay as if the substitute day were the actual public holiday. Section 29, subsection 1.1 stipulates that if a substitute day is designated for a public holiday, the employer must provide a written statement to the employee before the public holiday. This statement should include the public holiday being substituted, the date of the substituted day, and the date the statement is given to the employee, ensuring clarity and formal acknowledgement of the arrangement. Section 29, subsection 2 imposes restrictions on when the substituted day can be taken. The substitute day must be within 3 months of the original public holiday, or up to 12 months later if both the employee and employer agree. This flexibility allows for accommodation of various work schedules and personal circumstances. Section 29, subsection 2.1 addresses employees on leave or layoff. If a public holiday falls on a day that is not a regular working day for an employee who is on leave or layoff, the employee is entitled to public holiday pay for that day, but they do not have any other entitlement under this part with respect to the public holiday. However, Section 29, subsection 2.2 clarifies that the entitlement under subsection 2.1 does not apply if the employee's employment has been terminated under certain conditions and the public holiday falls on or after the day the layoff exceeded the period of a temporary layoff. Section 29, subsection 3 allows for an agreement between the employer and employee, where, instead of providing a substitute day, the employer pays the employee public holiday pay for the public holiday. If such an agreement is made, then subsection 1 does not apply. Finally, Section 29, subsection 4 notes an exception where the employee has no entitlement under subsections 1, 2.1, or 3 if they fail, without reasonable cause, to work their last regularly scheduled day of work before the public holiday or their first regularly scheduled day of work after the public holiday. Moving on to Section 30 of the ESA, this section addresses formal contracts and agreements between employees and employers regarding work on public holidays that fall on days not ordinarily worked or days when the employee is on vacation. Under such agreements, the provisions of Section 29 do not apply. Section 30, subsection 2 outlines the employee's entitlements in these situations. If a contract is made under subsection 1, the employer has 2 options for compensating the employee. The first option is to pay regular wages for the hours worked on the public holiday and provide another working day as a substitute holiday, with the employee receiving public holiday pay for this substitute day. Alternatively, the employer can pay public holiday pay for the day, plus premium pay for each hour worked, if both the employer and employee agree to this arrangement. Section 30, subsection 2.1 requires the employer to provide a written statement to the employee before the public holiday if a substitute day is designated. This statement should include the public holiday on which the employee will work, the date of the substituted day, and the date the statement is provided. Section 30, subsection 3 imposes restrictions on when the substituted day can be taken. The substitute day must be within 3 months of the original public holiday, or up to 12 months later if both the employee and employer agree. Section 30, subsection 4 provides detailed rules about the employee's entitlement under this arrangement, covering various scenarios of work performance on the public holiday. These rules include situations where the employee does not perform any of the agreed work work without reasonable cause, resulting in the loss of entitlements under subsection 2. If the employee performs some or all of the agreed work but fails to work their last scheduled day before or the first day after the public holiday without a valid reason, their entitlements are adjusted accordingly, typically resulting in premium pay for hours worked but no other benefits. These detailed provisions ensure that employees who agree to work on public holidays and fulfill their obligations are fairly compensated, while also setting clear expectations and consequences for attendance and performance around these days. If you've made it this far in the video, then congratulations. There are only 2 more sections left, and those are sections 31 and 32. Let's finish strong. Section 31 addresses the relationship between premium pay and overtime pay. If an employee receives premium pay for working on a public holiday, those hours for which they receive premium pay are not considered when calculating any overtime pay they may be entitled to. This distinction is crucial because it separates the compensation for working on public holidays from the standard calculations for overtime. Essentially, hours worked on public holidays at a premium rate are treated differently from regular hours worked for the purposes of overtime calculation, ensuring that employees are compensated fairly for holiday work without it impacting their standard overtime entitlements. Moving to section 32, this part deals with the situation where an employee's employment ends before they can take a substituted day off for a public holiday. In such cases, the employer is required to pay the employee public holiday pay for the substituted day. This payment should be calculated in accordance with subsection 11(5) of the ESA. This provision ensures that employees who leave their jobs before they can take advantage of a substituted public holiday still receive compensation for that holiday. It upholds the principle that employees are entitled to public holiday benefits, even if their employment ends before they can utilize a substituted holiday day. This section of the ESA ensures that employees who do not work on public holidays due to their usual work schedule or vacation still receive fair compensation, while also providing guidelines for how these situations should be managed. So if you were able to digest and process everything in this video, you can confidently say that your knowledge of what Ontario law has to say about holidays and holiday pay is probably better than your average Ontario law student. Don't forget to like, subscribe, and visit our website linked in the description for more legal insights. As always, I'm Ryan Keeney, and thanks for watching.